So at A Better Balance and the National Women's Law Center, we've spoken with dozens of women across the country who've been forced onto unpaid leave or fired when a relatively modest temporary accommodation could have kept them on the job and healthy during their pregnancy. And the result is that many women with temporary limitations in their ability to work because of pregnancy are being treated worse than those with similar limitations arising out of disabilities or injuries. And this is really an unfair and dangerous state of affairs. So in the recent report that we did with our coalition partner, A Better Balance, who's joining us on the webinar today, a recent report called It Shouldn't Be a Heavy Lift, Fair Treatment for Pregnant Workers, we tell the stories of 8 women who've experienced this type of discrimination, and we'll highlight 2 of those stories today. And as the report makes clear, these women were faced with a choice no one should have to make: either lose your income or risk your health and the health of your pregnancy. So in the webinar today, we're going to begin by giving you some information about this kind of pregnancy discrimination. We'll then give you an overview of current federal and state laws, as well as the gaps in current interpretation of the laws. And finally, we're going to talk about a policy agenda for addressing this problem. And as Amy said, we'll take questions at the end, so please hold your questions till then. And now, Dina Batts, if you could get us started. Dina is the president of A Better Balance.
Thanks, Emily. I'm thrilled everyone could join our call today to learn more about this fundamental women's health and economic security issue and explore ways to take action. As Emily said, it'll be 35 years in October after passage of the Pregnancy Discrimination Act, and yet all too often, pregnant workers find themselves without the law's protection, particularly workers living paycheck to paycheck. We routinely hear from pregnant workers who have been pushed out of their jobs after requesting a modest temporary accommodation, whether it's a stool, relief from heavy lifting, an extra bathroom break, accommodations routinely made to other workers that will allow them to continue working and maintain a healthy pregnancy. This happens all too frequently in too many workplaces in this country, and it disproportionately impacts women in low-wage and physically demanding jobs with little flexibility. Take, for example, a retail worker who was recently forced onto early disability leave because she could not climb to higher shelves to stock merchandise, or a New York care attendant who requested temporary relief from heavy lifting per doctor's orders. Instead, she was pushed out of her job and wound up in a homeless shelter 17 weeks pregnant. Other jobs in which women have sought and been denied accommodations include food service workers, stocking and packaging handlers, cashiers, police officers, mail carriers, office clerks. Women of color and immigrant women are particularly likely to work these low-wage jobs where there is little tolerance for flexibility. This lack of flexibility motivates and reinforces some employers' refusal to make the most basic accommodations. Non-traditional jobs like laborers, freight, stock, and material movers are also more likely to sometimes need accommodations at some point during their pregnancies to continue working safely. Yet women in these jobs, traditionally held by men, often face harassment, discrimination based on gender stereotypes, hostility, and suspicion. When a woman worker is already seen as an outsider, her pregnancy and any requests in her job related to the pregnancy can be taken as further evidence that the job is inappropriate for a woman, leading employers to refuse to make accommodations. The health and economic consequences are often devastating. For example, Guadalupe was a line worker at a Mexican fast food restaurant and got very positive performance reviews before she became pregnant. While pregnant, she needed to use the bathroom more frequently, but her boss yelled at her in front of the whole restaurant and declared that she would need permission from him to use the restroom and that she would have to inform all of her coworkers. Now, no other coworkers had to ask for permission to use the restroom. She was also forbidden from drinking water while on the line. All of her coworkers were also allowed to drink water on the line. She was ultimately fired in front of all of her coworkers after she left early for a prenatal appointment, an appointment she had notified her boss of previously. She went on government assistance, food stamps, and unemployment benefits for the first time in her life. She was not able to find other work because employers did not want to hire a pregnant woman. She was the sole breadwinner for her family. This real story from on the ground demonstrates the inflexibility and harsh conditions facing many low-wage workers and how easy it would be for many employers to simply grant accommodation requests. When pregnant workers like Guadalupe are denied basic accommodations and forced off the job, whole families pay a steep price. Women denied accommodations are routinely placed on unpaid leave and set back with lost wages. and when they return to work, missed advancement opportunities, exacerbating the maternal wage gap. Some pregnant workers who work for larger employers often use up their 12-week FMLA leave before their baby is born, leaving little time for childbirth, recovery from childbirth, to establish breastfeeding or bond with a new baby before returning to work. Others are still pregnant at the end of this fourth FMLA leave period and are then terminated. Women who are flat out let go don't just lose out on critical income. They are often terrified by the reality that they have no way to support their new baby and no way back into a market that is especially brutal on the unemployed, particularly new mothers who often confront an even greater bias when looking for work. Women who quit their jobs because they are unwilling to risk their health are often not eligible for unemployment insurance because they are considered to have voluntarily quit. And similarly, pregnant women denied accommodations are also often ineligible for state disability insurance benefits or employer-provided disability benefits because they are able to work with an accommodation and are not categorized as disabled. Women who quit or lose their jobs are often lose their health insurance at a critical moment and found themselves having to shoulder exorbitantly expensive medical care on their own. The financial hit can obviously be devastating to pregnant women and their families, as women are increasing the family breadwinner. Between 2006 and 2008, nearly 2/3 of first-time mothers worked while pregnant, and over 80% worked in their last months of pregnancy. Women in low-income families are particularly likely to be the family breadwinners. In married couple families with children in the bottom income quintile, nearly 70% of working wives are breadwinners who earn as much or more than their husbands, and more than 72% of single mothers worked in 2011, providing critical income as heads of households. Bottom line, for families today, and particularly those struggling financially, when pregnant workers are forced out of a job, whole families pay a price. As a result, when pregnant women are denied physician-directed workplace modifications, they often feel they have no choice but to continue on with their assigned job duties in order to make ends meet. Other women are deterred from even asking for accommodations for fear of losing their jobs. Oftentimes, this fear is very rational. They may have seen a coworker experience trouble at work because of pregnancy, or they themselves might have encountered problems during a previous pregnancy. Unfortunately, there are many health risks, and the list is long. But these health risks are simply unacceptable when they could be avoided by providing a temporary modification. Hilda's story demonstrates the health consequences and costs of failing to provide reasonable accommodations to pregnant workers. Hilda became pregnant while working at a Dollar Tree store. She had to stand at the cash register for 10-hour shifts. Her boss refused to give her a stool after she asked for one. He told her, "You can't get special treatment since a man can't get pregnant." The pressure from standing all day caused bleeding and premature labor pains. She went to the ER every few days. Her doctor eventually put her on bed rest to get her off her feet, even though she could have continued working if she had just had a stool to sit on. She had no paid leave or income, and the economic consequences were devastating to Hilda and her family. She recently visited another Dollar Tree store where an employee who wasn't pregnant was sitting down and told her that her store branch let them work on stools. This type of inconsistency in policy and practice is simply unacceptable. Fair treatment shouldn't depend on your manager or your office branch. Hilda's story also demonstrates that accommodations are routinely low cost or no cost to employers. In fact, employers that provide accommodations to workers with disabilities and voluntary flexibility programs report a strong return on investment, and I'll return to this point a little later. In addition, accommodations save taxpayers money in the form of unemployment insurance and other public benefits. Emily will now lead a discussion of the federal legal landscape and case for action, and then I'll return to a discussion of model state legislation, messaging, and state action. Emily? Hello? Emily?
Sorry. I pressed my unmute, but I pressed it too hard, I guess, and remuted. Thank you, Dana. The good news is that federal law provides important protections to pregnant workers who need accommodation. But the bad news is that courts have sometimes read these laws inappropriately narrowly and created loopholes that harm pregnant women. So there are three important federal laws here that we'll talk about briefly today: the Americans with Disabilities Act, the Pregnancy Discrimination Act, and the Family and Medical Leave Act. So we're going to start with the ADA, the Americans with Disabilities Act. As you probably know, it requires employers to make reasonable accommodations for employees with disabilities, as long as those accommodations don't impose an undue hardship on the employer. Now, in 2008, the ADA Amendments Act, also called the ADAAA, expanded the definition of disability under the ADA significantly to include temporary and less severe impairments. So pregnancy itself is not a disability under the ADA. It's not considered an impairment, so it's not a disability. And prior to 2008, when the ADAAA was passed, it used to be that pregnancy-related impairments also generally were held not to be disabilities because they were temporary. But since 2008, since the ADAAA was passed, a pregnancy-related impairment can be a disability if it substantially limits a major life activity, such as walking or lifting or digesting or working in a particular kind of job. So what this means is that pregnancy-related impairments such as hypertension or severe nausea or sciatica or gestational diabetes, all of those will often be disabilities covered directly by the ADA. And EEOC regulations interpreting the ADA explicitly state this. So in some cases, the ADA covers and mandates reasonable accommodation for pregnant workers when they need accommodation for pregnancy-related disability. And too many employers don't understand that, but it is the case. The next important law we're going to talk about is the Pregnancy Discrimination Act. Now, some of the key purposes of the PDA were to prohibit employers from forcing pregnant women out of the workplace when they were able to continue working, and also to keep employers from treating pregnancy uniquely worse than other conditions. So what the PDA does, it prohibits discrimination on the basis of pregnancy, and it explicitly requires employers to treat pregnant workers like the employer treats other employees who are similar in their ability or inability to work. That's the language of the PDA. Now, the EEOC has long interpreted this PDA language to mean that employers must provide the same accommodations to pregnant workers as they do for workers with temporary disabilities. So if you can't lift because of pregnancy, you should be treated just like your employer treats your coworker who can't lift because of a back injury. However, some courts have allowed employers to reject requests for accommodations from pregnant workers even when they grant similar accommodations to employees with disabilities, as they must under law, or to workers with on-the-job injuries. So, for example, earlier this year, the Fourth Circuit Court of Appeals decided a case called Young versus UPS, a pregnancy discrimination case brought by a woman named Peggy Young, who was a UPS driver, forced off the job when her doctor recommended that she avoid heavy lifting because of her pregnancy. Now, UPS provides light duty to workers with ADA qualifying disabilities, workers injured on the job, and workers who've lost their commercial driver's license because of health conditions or even because of drunk driving violations. It doesn't provide light duty to pregnant workers. But the Fourth Circuit nevertheless concluded that even though UPS denies pregnant workers accommodations while granting them to workers with similar limitations in their ability to work, that this was a pregnancy blind rule that didn't violate the PDA. In essence, the Fourth Circuit reasoned that the PDA can't mean what it says. And too often, pregnant workers have faced that sort of hostility in the courts. So now that the ADAAA is law, the Pregnancy Discrimination Act and the ADA work together in important ways, in ways that are particularly important to pregnant workers who need accommodations. So the ADAAA now requires accommodations of workers with temporary disabilities like a back injury requiring a lifting restriction, or like a leg condition that keeps you from standing for more than 2 hours without discomfort, or like a condition causing shortness of breath when you're walking a reasonable distance. And the Pregnancy Discrimination Act says that you, the employer, have to treat pregnant workers as well as you treat those with similar limitations. So reading these laws together, employers must now accommodate pregnant workers who can't lift or can't stand for long periods of time, or who lose their breath when walking. In other words, the ADA's accommodation rule intersects with the PDA's longstanding equal treatment requirement and ensures that now that you have to accommodate workers with temporary disabilities, you have to treat the pregnant worker just as well. You have to accommodate her as well. Now, to date, courts have not addressed this interaction, but it's important to note that the ADAAA provides a basis for distinguishing cases like Young versus UPS that rely on the older version of the ADA. So for example, in Young, the court held that pregnant workers weren't similarly situated to workers with disabilities because the ADA only covered workers with severe and permanent disabilities. But that's no longer the case. It won't be the case when the next pregnant worker brings her case. Now, I also wanted to briefly touch on the Family Medical Leave Act. The Family Medical Leave Act provides eligible employees with up to 12 weeks of job-protected unpaid leave for an inability to work that arises out of pregnancy, or for care for a new child, or for a serious health condition of the employee or an employee's family member. And it specifically, the FMLA regulations specifically mention that intermittent FMLA leave may be used for pregnancy-related illness, such as morning sickness, as well as for prenatal appointments. So in other words, if a pregnant employee needs an accommodation in the form of time off, the FMLA may well provide it. Now, unfortunately, the flip side of this is that, as you've heard us say already today, employers often force pregnant workers to go on FMLA leave rather than making reasonable accommodations, thus causing those employees to lose income and to use up all or most of their leave before their babies are even born. And then the worker is often fired once her 12-week FMLA leave period is over, which again will often be before her baby is even born. So the FMLA provides crucial job protection for employees who can't work, but it doesn't do so much for employees who want to work and could do so with reasonable changes to the job. Well, finally, some states have explicitly addressed this in state law. 8 states explicitly require some or all employers to provide certain types of accommodations to pregnant workers. And those states, as you see on the slide, are Alaska, California, Connecticut, Hawaii, Illinois, Louisiana, Maryland, and Texas. Maryland is the most recent addition to that club. Their law just passed this spring. Now, of these states, California likely provides the broadest protection, requiring reasonable accommodations for conditions related to pregnancy, childbirth, or a related medical condition when those accommodations are sought upon the advice of a physician. Hawaii and Maryland explicitly require accommodation for pregnancy-related disabilities. Louisiana and Connecticut provide that employers must transfer pregnant employees to less hazardous positions if the worker seeks it and the employer can reasonably do so. And Alaska, Illinois, and Texas require certain accommodations for some categories of public employees. So not for all employers in the state, but for some public employees. And various states are looking at this issue now. So just in the last year, legislation was introduced in Illinois, Iowa, Maine, Minnesota, New Jersey, and New York, explicitly addressing pregnancy accommodations. New York City is considering such a law as well. And I think it's an area where we can definitely expect further state legislative interest. And in part that is because that this is an issue that is compelling to people and that people understand. Recent polling indicates that there is really intense and broad public support for strengthening policies to prevent employers from firing or demoting women when they get pregnant or take maternity leave. Now this polling, which is frankly the first polling I have seen on pregnancy discrimination issues, so I was surprised at the depth of support, shows that strengthening these sorts of protections for pregnant workers enjoys 91% support with the American public, with 70% saying they strongly favor it. And the pollsters characterized this number as strikingly powerful. It was up there with protecting Medicare benefits for current retirees. It was a very strong showing. And the polling shows even more overwhelming support among the important voting bloc of unmarried women. It's an issue that resonates and that people understand. So I want to talk briefly about what we see as the federal agenda for action on this issue, and then Dina will talk more about the state policy agenda. First, federal agencies should provide guidance on these questions, and the most important agency to act is the EEOC. Now, the good news is that late last year, the EEOC identified pregnancy accommodations as a national enforcement priority through 2016. which is basically the EEOC's statement that they're taking this issue seriously, that they're looking at it closely, and they think that there is a real problem here that bears attention, which is great. However, the EEOC has yet to issue guidance to employers on their obligations to accommodate pregnant workers, and it should. It should make clear that first, employers must accommodate employees with limitations arising out of pregnancy if they would accommodate workers with equivalent limitations arising out of disability under the ADA. In addition, the EEOC should make clear that many pregnancy-related impairments now rise to the level of disability under the ADA and must be accommodated. And the EEOC should prioritize investigations of complaints by pregnant workers alleging unlawful denial of accommodations, especially among the low-wage workers where this problem hits the hardest and where workers are the least likely to be able to find the legal resources to pursue these cases on their own. So EEOC clarification and guidance would help courts as well as employers, and this is an important window of opportunity when courts will be considering the interaction of the ADAAA and the Pregnancy Discrimination Act and what that means for the very first time. We also think that Congress should pass the Pregnant Workers Fairness Act to provide necessary clarity in the law. The Pregnant Workers Fairness Act was first introduced in 2012. It was reintroduced in this Congress. The leads are Senator Casey and Senator Shaheen in the Senate and Congressman Nadler in the House. There are 14 co-sponsors in the Senate and 101 co-sponsors in the House, currently all Democrats, though we think there are lots of reasons why this should be bipartisan and hope that eventually it will be. What the Pregnant Workers Fairness Act would do is explicitly require employers to provide reasonable accommodation to pregnant workers who need it, unless doing so would impose an undue hardship. So it uses the same concepts from the ADA. It's thus easy for employers to understand. It is easy to enforce because it follows a pattern that people are familiar with. And we think that while current law often does require accommodations, the Pregnant Workers Fairness Act would be very valuable because it makes this unmistakable. And there is a real value in having a clear, unambiguous rule. For example, since California adopted its explicit pregnancy accommodation requirement, the state's seen fewer pregnancy discrimination lawsuits, which shows the importance of having a clear rule, which gives employers and workers understanding of what their rights are. And state advocates have an important role to play with this federal agenda. And Dina's going to talk more about all the things that we think state advocates should do. But specifically at every level of advocacy, compelling stories are key. So story collection is so important. Stories from workers who needed accommodations, from businesses with good policies who can talk about why they think accommodations are good for business, stories from healthcare providers who can explain the consequences of failures to accommodate. These are all key to moving public opinion and thus moving policymaker opinion. And relatedly, identifying potential allies, people who might not expect, who might care about this issue and be persuasive spokespeople, whether it's businesses and business groups, healthcare providers, religious leaders. That is also key to moving public opinion and getting policymakers' attention. And of course, hearing from local constituents is always important to Congress and serves to motivate in a way that really nothing else can. And there's also some value in writing to the EEOC, urging action on pregnancy accommodation, since decisions about what guidance is going to be issued and what it looks like are definitely being made now. And it's possible there will be a formal opportunity for public comment on proposed guidance down the road where the input of stakeholders will be crucial. And there's a need for advocacy at the state and local level, both for its own sake, but also as a prod to federal action, as such advocacy builds momentum. So with that, Dina, can you talk a little bit more about the state policy agenda?
Sure. Thanks, Emily. So while a Better Balance National Women's Law Center and our wonderful coalition partners push for reform on the federal level, we believe state action is vital and can help drive federal reform and add new protections for workers. In fact, it was Action New York that led to the introduction of the Federal Pregnant Workers Fairness Act after New York Times op-ed raised awareness of the problem in early 2012, and a state law fix to address it. New York Representatives Nadler and Maloney brought this issue to every member of Congress, and the Pregnant Workers Fairness Act was introduced just a few months later. While we advocate for federal reform, state lawmakers do have a great opportunity to lead the way here. Governor Cuomo is a wonderful example here. This past year, his Women's Equality Agenda identified pregnancy discrimination, and this issue in particular, this form of discrimination, as a key women's equality issue. Based on our experience on the state and federal level, we want to discuss with you all some of the most compelling reasons for state and local action. First, as Emily mentioned earlier, state action is necessary to address ambiguity and provide clarity in our legal scheme. There is tremendous confusion in the courts and among employers about the scope of protection of federal and state disability law. It varies by states. Some states have no specific accommodation language and follow federal law. Other states have legislation that is slightly broader. The problem is that what rises to the level of disability remains a great source of confusion to the courts and to employers. The result, we've seen employers refuse to apply their disability accommodation policy and procedures to pregnant workers, even if federal and state law would actually cover their pregnancy-related condition. State laws also vary to the extent that sex or pregnancy discrimination laws might cover this form of discrimination, and there is similar confusion and inconsistency. Second, clear legal protections would not only benefit pregnant women, employers would benefit too. Again, as Emily said earlier, existing law requires accommodation, but employers often have no idea. A clear statement of law would go a long way towards providing the clarity they need to implement effective and consistent HR policies and reduce the risk and cost of litigation. Third, time is of the essence. Pregnant women do not have time for agency actions or lawsuits, when sometimes can drag on for months or years. A proactive tool which allows them to go directly to their employers avoids the cost and hassle of bringing a judge or an agency into it, and greatly increases the chance that women can stay on the job. They simply don't have time to spare for a determination. They need a proactive legal right in order to keep their health insurance, save their FMLA leave for post-childbirth, and continue earning their paychecks when they need them the most. For women who suffer health consequences as a result of an accommodation denial, any reactive right can be too little too late. And finally, state and local human rights laws often cover smaller employers than federal law, and amending these existing laws will assist a larger percentage of women. A couple minutes on just state model language. State reasonable accommodation for pregnancy legislation, if you're considering introducing it, will vary from state to state depending on existing state laws and protections. There is no one-size-fits-all approach, although there are some key language concepts. Legislators, first and foremost, must look at existing sex and disability discrimination laws and analyze them before attempting to add new laws. Language will also vary based on existing state agency interpretation and guidance. It's imperative that advocates have help analyzing the existing state legislative framework before creating new language, and we are available to provide this type of assistance. And again, California's law is an excellent example of language that has been used successfully for over a decade. This law does not try to simply use comparator language, meaning that it does not merely say that pregnant workers should be treated the same as another group. Instead, it provides a proactive legal right to workers for conditions related to pregnancy and childbirth. Although existing federal and state laws cover a wide range of pregnancy disabilities, there is an opportunity for new state laws to expand coverage to healthy pregnancy conditions that do not necessarily rise to the level of a disability, but still require some adjustments at work per doctor's orders. For example, a woman who is 8 months pregnant might be at risk of dehydration if she didn't drink water frequently, but does not suffer from a physical impairment. It would not necessarily be covered under disability law. Nevertheless, she might need a reasonable accommodation of access to more frequent water breaks or carrying a water bottle. One common way to incorporate broader language like this is to use language similar to California's and require the employer to reasonably accommodate conditions related to pregnancy and childbirth. The important thing to remember is that the law should not just protect disabilities, but conditions or needs associated with healthy pregnancies as well. Bottom line, women should not have to consult an attorney or go through a grueling process to find out if they're covered. They cannot afford, we see it all the time, weeks for this crucial determination. Women should feel secure in their rights to advocate for themselves, and clear legislation would provide this added certainty. As we advance this issue, you should keep in mind the messaging that will be the most helpful to make your campaign a success. We wanted to discuss a few of the strongest themes that have proven helpful for garnering support in the past. First is the healthy pregnancy bucket. Simply this: no pregnant woman should be forced to choose between following a doctor's order or a supervisor's directive, nor should a pregnant worker be forced with deciding to work under unhealthy conditions or losing a paycheck. In New York, we were able to secure testimony from Dr. Lucy Willis, who treated a pregnant patient in the ER who had fainted and collapsed while working as a cashier because her boss would not let her drink water while on the job. This testimony proved really powerful on both the state and city level in demonstrating how important it is to provide reasonable accommodations that allow workers to stay on the job and maintain a healthy pregnancy. Messaging this issue as a vitally important public health measure can also be effective for gaining bipartisan support. A second important message: this legislation is fundamentally about equal opportunity, not preferential or special treatment, equal opportunity. As we've discussed, employers are already required to provide accommodations to workers with disabilities. Pregnant workers deserve the same treatment to ensure a level playing field. Too many legislators fail to understand that because of the way our laws have been construed by the courts, pregnant women are routinely treated worse by their employers than similarly situated workers. This message also helps employers and the public understand that since employers are already providing the same type of accommodations to workers with disabilities, it's reasonable, logical to ask them to ensure that they are also providing the same type of protections to pregnant workers. And finally, equal opportunity for pregnant women, new mothers, boosts wages for women, and promotes family economic security. A third theme or key point has to do with business. It's imperative you make the case to business leaders early on about the business benefits of the law. In New York, we were extremely fortunate to have a progressive chamber leader who got it right away. Her willingness to stand up for this bill and the entire women's equality agenda had a huge impact in getting other business leaders to speak out in support and understand the business case for fair treatment. She joined conference calls, rallies, meetings with statewide chamber leaders. Her leadership was and is essential. I'm so pleased to introduce Cynthia DiPartolo, Chair of the Greater New York Chamber of Commerce and CEO of Tigris Financial Partners. Cynthia?
Good afternoon, and good afternoon all of our guests. Thank you for joining us for this critical issue. As the chairperson of the Greater New York Chamber of Commerce, which provides valuable services to over 20,000 businesses and civic leaders who represent the backbone of the Greater New York business community, I am also serving as a leader of the New York Women's Equality Coalition, a group of over 850,000 organizations who came together to support Governor Cuomo's Women's Equality Agenda, a multifaceted agenda to extinguish barriers that perpetuate discrimination against women. I support strengthening legal protections for pregnant workers as a women's equality issue. This form of sex discrimination is not only bad for women, it is bad for business. There is no question that providing equal opportunities for women is critical to our country's economic future. In order for business, labor, and America to prosper, we must work together to improve the workplace for women, including pregnant women. And businesses depend on a female workforce. So therefore, it is only natural that issues affecting their health, their safety, and economic stability be a priority. Companies that invest in and empower women are at an advantage because they attract and retain qualified employees. They increase productivity and reduce costly turnover. These businesses show themselves to be stronger companies and, not surprisingly, have better long-term investments. Gender parity is good business, and executives must frame equality as a strategic imperative. Increasing women's participation in the economy by creating an improved workplace will have a dramatic impact on the competitiveness and growth of our companies and our economy. We must not delay in harnessing the power of women for sustainable business growth. I urge you all to join us in this fight. I hope at this point you're thinking, how can my chamber leaders and supportive businesses help us? To any business leader in our audience who would like to get involved in a supportive business coalition, please contact the hosts of this webinar, Dina Basket of A Better Balance and Emily Martin of the National Women's Labor Center. I hope that you're also asking yourself at this point, as a business leader, how can you help with local efforts to end discrimination against pregnant workers? Well, here's a few ideas. Check your current policies to make sure that they are up to date. Employers can and should lead the way with progressive business practices. Having a written policy in place of providing reasonable accommodations for pregnant workers is an excellent way to ensure consistency in your company. Let's advocate and let the public know about your company's progressive policies and the business benefits of having a zero tolerance for any form of discrimination. How about just simply drafting a letter of support, explaining why this is sound business practice, and ask your colleagues to sign it, and then circulate it among their partners? In New York, I've worked with A Better Balance and spearheaded a successful business letter of support of Governor Cuomo's Women's Equality Act, a 10-point plan to break down barriers faced by women in the workplace, including a provision to combat this form of pregnancy discrimination. This effort helped to bring on small and large businesses and their leaders, and we've had significant impact. Also, I just wrote a similar letter in support of the Federal Pregnant Workers Fairness Act and hope our support in New York can encourage other chambers and business leaders to follow suit. I urge you to reach out to Dina Basket if you're interested in a copy of this letter. I also raised the issue of multiple business forums and urge those leaders that I collectively collaborate with to get involved in our New York community. And I spoke at large rallies and advocated for this exact protection. Take the time. Write an op-ed piece or a letter to your editor of your local paper about why you support this measure and why you have a non-discrimination policy in place. Finally, get in touch with your local advocates. Remind them they can help you help them. Thank you, ladies.
Thank you so much, Cynthia. We are so grateful for your participation. Business support is critical in our work, and your unwavering support for progressive policies to help level the playing field and advance women in the workplace is exceptional. Just a follow-up point for advocates who will be asking businesses for their support, a few other points to highlight. Again, many of these protections are already required under federal, state, and local law, but clear and consistent policies would reduce liability for pregnancy discrimination while also giving predictability to employers and managers. And the reduction of risk, as Emily said earlier, has been demonstrated in California, which saw a decrease in pregnancy discrimination litigation after passing similar legislation. And other benefits include reduced turnover and absenteeism, increased employee satisfaction, productivity, savings in workers' comp, and other insurance costs. Progressive policies are also, frankly, great PR for a company. Consumers and clients want to work with companies that are champions for women. And finally, the cost of accommodating disabled workers and implementing workplace disability programs are typically low or non-existent. A survey by the Job Accommodation Network found that the majority of employers that provided accommodation to employees with disabilities reported the accommodations did not impose any new costs on the employer. Of those employers that reported a cost for accommodation, the majority reported a one-time cost of $500 or less. Since accommodations for pregnant workers are temporary costs, if any, of providing these accommodations can be anticipated to be even less. And most versions of this legislation also include some sort of undue hardship exemption. So if a requested accommodation was excessively expensive, it would not be required. Similarly, accommodations only have to be reasonable. Workers are not entitled to anything under the sun. Lastly, coalition building, just a word. Fair treatment for pregnant workers, as Emily said, is an issue that has broad support. It polls well, and it should be a policy priority for many diverse groups: labor, anti-poverty, civil rights, grassroots organizations, reproductive health. We really urge you to forge new alliances with a wide range of partners to build support. And don't forget to enlist business support from the outset. This is critical. Organizing sign-on letters, press conferences, rallies, collecting personal stories, and creating compelling materials and effective messages to appeal to a bipartisan and business audience, all of these advocacy efforts are vitally important and can help strengthen your chance of success. We organize this call to give you a greater understanding of the issue, opportunities for reform, and some key messages. But both A Better Balance and the Law Center, as well as our coalition partners, have many additional resources to assist you. Model language, fact sheets, business PowerPoint. We hope you won't hesitate to reach out. Now I'd like to turn it to Liz Watson from the Law Center, who will moderate questions.
Thank you. I'm going to ask some of the questions that our callers have asked during the course of the webinar of our presenters. And our first question is for Dina. Dina, our callers would like to know if there is model legislation that would be helpful to advocates who are working in the states and would like to put together legislation requiring accommodations for pregnant workers.
Yeah, A Better Balance and the Legal Aid Employment Law Center in California, along with input from our coalition partners, have written a model language guide with many key principles we discussed today and more.
Dina, you need to unmute your phone. I think folks can't hear you.
Is that better?
Okay, we can hear you now. Yep.
Okay, sorry about that. A Better Balance and the Legal Aid Employment Society in California, along with our with input from our coalition partners, have written a model language guide with many key principles that we've discussed today and more. And you can reach out to us, specifically Elizabeth Gedmark at A Better Balance, Gedmark at abetterbalance.org. We will also be sending follow-up information to all webinar participants.
Thank you, Dina. And we have some questions from organizations and individuals who would like to know one or two things that they can do to support fair treatment for pregnant workers. This question is going to go to Emily Martin. Emily, folks would like to know if they want to help but don't have a lot of time, what are one or two things you recommend they should do?
Well, one easy thing that you can do is make sure that you are signed up for alerts from the National Women's Law Center, since what we like to do is to let you know when there is a particular moment where just signing an email or making a phone call could make a real difference. And this is definitely an issue where we are doing a lot of work, so we'll definitely let you know when it's the moment to call your representative or to submit comments to the EEOC. So that is one easy thing to do. Another thing to do, depending on where you're sitting, but if you are working for an organization with a set of interests that could be allied with this issue, definitely reach out to us about becoming part of our coalition, where we have periodic conversations about strategy. And many of our asks to coalition members are also very simple, as far as join this letter or make a call to your representative. So those are two simple things to do to learn more and to make sure that you stay in the loop.
Thank you, Emily. And this next question goes to Dina. One of our callers asks, are there reports or studies about the health impacts of failure to accommodate pregnancy? How does this impact women in their lives? And can you tell us some resources that are useful for advocates on that score?
Sure. Yeah, A Better Balance and the National Women's Law Center just published a report precisely addressing this question. It shouldn't be a heavy lift, which features the stories of real women from across the country who suffer this form of discrimination. The report also is full of recent statistics that show how important it is for working families, economic security, and the public health benefits of providing reasonable accommodations for pregnancy-related conditions. We have some testimony from doctors and some reports that we're also happy to share with folks. So feel free to reach out.
Thank you, Dina. And this next question goes to Cynthia and to Emily. Both of you are welcome to answer. Can you give us just a couple of ideas about what businesses can do who want to make sure that this kind of discrimination doesn't occur in their workplaces? So what kind of advice would you give to an HR director or a person in management about how to protect against this form of discrimination? So Cynthia, why don't we get your thoughts first?
Yeah, as a business owner, I'll give it to you. As a business owner, I would be very concerned and that I have a policy in place, that I have written procedures in place that have a zero tolerance policy. Beyond that, I would make sure that I have some sort of education and training in place for my staff. I think it's very important that you not only have a written manual and policy, that people are aware of it, so therefore they need sensitivity training. They need to be aware of the policy, and they also need to be aware of the consequences if they don't conform to the policy. People that feel they are victimized or discriminated against need to understand what the procedure is to follow, and also that they need to feel comfortable that they will not suffer retaliation if they were to raise this type of claim. In summary, that's what I would do as the steps to protect myself as an owner of a business.
Okay, Emily, I can't add a, sorry. This is Emily. I can't add a lot more to that, but I would say that in creating that policy as an HR director, definitely pay attention to what policies you already have about accommodating disability or accommodating injuries, and make sure that you're treating pregnant workers as well as you're treating workers who need those other forms, those accommodations for other reasons, since that is one key question that will be asked if a pregnant worker says that she was discriminated against by you.
Thank you, Emily. And one of our participants asks, are these protections that we're talking about here today, the ADA as amended, the PDA, and the FMLA, are these available to farm workers?
They are. While farm workers are left out of some important laws, they are not left out of the ADA or Title VII, which the Pregnancy Discrimination Act falls within. So the protections against discrimination, the requirements of reasonable accommodation under the ADA, those extend to farm workers as well.
Thank you, Emily. And Emily, here's one more question for you. What advice would you give to a woman who has been told by her doctor that she has work restrictions related to her pregnancy? How should she approach her employer? And what should she do if she gets to this stage, the unfortunate stage, where she's requested an accommodation and has been denied? Can you mention the EEOC, their website, and the deadlines for filing charges?
Sure. Well, to take the second half of your question first, if she is, after whatever happens to the employer in a situation where she's being denied an accommodation, where she thinks that her rights have been violated, what she needs to do is to bring, if she can't otherwise resolve it by talking to her employer, bring an EEOC charge and do it relatively quickly, because there are pretty short time limits on your ability to file a charge. At the most, you only have 300 days. You may just have 180 days in some states. So go to eeoc.gov and you can learn more about that process. But to go back to the beginning, where hopefully we never get to that point, if a woman has a work restriction from her doctor, obviously she needs to talk to her employer about that. But it probably is a good idea for her to gather as much information as she can going in, whether from employee handbooks or from her coworkers or both, about what the employer's policy is and what the employer's actual practice is as far as accommodating limitations, whether they're for pregnancy or whether they're because of disability or whether they're because of injury, so that she can basically make the most persuasive case that her employer really needs to be accommodating her under its own policies, or to make sure that the employer is not treating her worse than it has treated other employees who are similar in their ability to work, as the PDA says.
And I was just going to add to that, Emily, if you're done, is that in addition, it's about doing your homework under state and local laws, and we and other coalition partners have information on our website about other publications about how relevant laws apply. But the other important thing relates to doctor's notes. And if a woman has a doctor's note indicating that her work-related restriction relates to her pregnancy-related disability, she should make clear to her employer that she knows she's likely covered and entitled to an interactive process to assess the availability of an accommodation. That's really the first step, is being entitled to an interactive process. And some women who are not perceived to have a disability are summarily pushed out of that process and put on leave. And she should also be very specific to her employer about the job functions she still can perform. Many employers wrongly assume pregnant women can't do the functions of their job when they receive a doctor's note. So I urge pregnant women to be very specific about the functions of the job they can do. And finally, it's important that pregnant women try to make it clear about how, make it easier for supervisors to show that they've thought through how the limitations will affect their job, and perhaps, if possible, come up with a workable solution.
Thank you, Dina. And one of our participants asks us to address the recent bill that was introduced in Florida protecting women against pregnancy discrimination. Emily, could you talk about that bill?
Sure, though it is possible that there's something I don't know about it. So if you participant from Florida who knows more about it, see that I'm getting it wrong, please feel free to shoot a message and we'll try to correct. My understanding of the bill in Florida is that it makes clear that pregnancy discrimination is illegal under state law, which right now is a subject of some debate in Florida's state courts. Which is obviously incredibly important and a first step to bringing any sort of pregnancy discrimination claim under state law. What I'm not aware that it does is address the accommodation issue directly. I hope that it does. I was not aware that it did, if it does. But maybe it should, because as we've discussed, one of the things that is really helpful here is when employers and workers and courts have clarity about what the law means and what the law requires. And while, as you've heard, we believe in lots of cases, the ADA and the pregnancy discrimination laws and the state equivalents require accommodations, it requires some explaining. And it's all the simpler when the law says this clearly and explicitly. So definitely it is something to consider adding in addition to the necessary protections against pregnancy discrimination.
Thank you, Emily. And this last question is for Dina. Dina, can you tell us a little bit more about where state legislators, advocates, businesses, and others can find resources to support their efforts on behalf of pregnant workers?
Sure. Well, first, ABB, the National Women's Law Center, websites have many resources to help you, and we'll send a follow-up email with a lot of materials and information to everyone available who signed up for this webinar. And of course, don't hesitate to contact us directly if you have any specific needs, like if you'd like a PowerPoint presentation to explain this concept simply and directly to businesses, and fact sheets and other materials. In addition, many of our fantastic partner organizations really have wonderful resources on their websites too, some of which are state-specific. And we would be happy to connect you with them as well. The Job Accommodations Network, AskJan.org, is a service of the Office of Disability Employment Policy with the U.S. Department of Labor and can answer questions about common reasonable accommodations. They also have a webpage specifically about pregnancy accommodations. So check it out. And finally, the EEOC has information on its website, and your local state and local human rights agencies or enforcing body might have Know Your Rights guides or other resources as well. So be sure to check it out. And I think there was a final question about retaliation, and I just was going to add that, it is illegal under each of these laws we've talked about today for an employer to retaliate against a worker who asserts their rights under the law or files a claim alleging discrimination. So this is just important to remember.
Okay, thank you all so much for joining us today. I thank Dina, Emily, Cynthia, and Liz for facilitating this webinar. When the webinar ends, you will see a short survey that I encourage you all to fill out so we can improve our webinars each time we do them. And you will also receive a follow-up email with a link to a recording of this webinar, as well as the PowerPoint slides in the coming days. So take care, and I hope you all have a great afternoon.